talking about what is a constitution and a constitutional document. So there are two basic purposes or functions of a constitution that I want you to know. The first thing that a constitutional type document does is organize how a government or whatever entity it is, so in this case of the U.S. Constitution, how is the federal government set up? The basic organizational structure of the United States government. That's one of the purposes of the Constitution, to organize government. Or in a corporation, to organize a corporation, or a nonprofit, or whatever, okay? But we're talking about the federal government right now. The second purpose of a constitution, and this is a test question, it's a multiple choice question usually. The second purpose of a constitutional document is to define and reserve rights to the people and the states, in the case of the federal constitution. All right, so the two basic purposes of a constitution: number one, to organize, and number two, to define and reserve rights. Define and reserve rights, or just reserve rights, okay? So let's start off with that first function. That is the organizational function of the U.S. Constitution. So page 6. Or page 5, depending on which you're page. All right. So this is an index of the U.S. Constitution. And I want to focus right now on Articles 1, 2, and 3, right here. So Article 1 of the United States Constitution establishes the legislative department. Article 2 establishes the executive department, and Article 3 establishes the judicial department. Right? So our federal government, through the U.S. Constitution, the organizational function, creates three separate branches of government. Three separate branches. And each branch has a basic power, basic authority, the basic job, if you will. One of the fundamental powers of a government. So let's look at these in more detail. Next page. So here we go. So this is the first sentence of Article 1 of the U.S. Constitution. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. All right? So that creates Congress, Article 1 of the Constitution. So, legislative power, it's one of the fundamental powers a government can have. What is legislative power? What does that mean? Does it mean no? The power to legislate. What's the basic function of the legislative branch? To do what with law? Create. I like the word create, absolutely. Create new laws or amend existing laws. In other words, the basic function, in plain language, is to make law, right? So the idea is one of the basic functions of a government, doesn't matter if it's the United States or Germany or whatever, is to make law that applies to the people, to the masses, and to the government itself. So when I say legislative power, that is the power to create law, to make law, to write law, however you want to phrase it, okay? Now, it's more than just the power to write law. I mean, I could sit down with my pen right now, and I could write a law. I'm a lawyer. The law says, I hereby impose a 100% tax on everybody and all of your income payable to the John Hasbrook wants to go to Italy next summer fund. Right? So I just wrote a law. But the problem is, So I start handing it out to everybody. The problem, you guys all laugh, right? Yeah, that's funny. The problem is I don't have legislative power. I could write what I call a law, but I don't have the power to impose it. Legislative power is part one, the ability to write a law. But on a larger level, it's the ability to, yes, write a law, but the power to impose it on the public or on some segment of the public, all right? So when I say legislative, it's not just writing law. It is the power to impose the law, if you will. One of the fundamental functions of a government, right? Okay. Next, we have Article 2, which establishes the executive department, the executive branch. The executive power shall be vested in a president of the United States. All right, so executive power, the executive branch. What is the basic function of an executive branch? To do what with the law? Enforce. That's the word I'm looking for. So the idea is the legislature will make the law, and then the executive branch, their job is to enforce the law that was written by the legislature. Now when we say enforce, that's a very broad term, right? I mean, what do we mean by it? When I say enforce the law, what's the first thing you think? The police, right? Okay. So it says here the executive power shall be vested in the president. Does that mean the president is driving around a police car, executing search warrants, pulling people over, giving them a DUI, and all that? No. All right? So the enforcement power is delegated. That's what I'm leading up to. All right? It's transferred from the president, the office of the president, out through various channels. And this is a big issue. It always has been, but the last 30 years especially, we've seen this shift. So when I talk about the executive branch, within the executive branch, we're also talking about the police powers and enforcement powers that we find in police agencies, administrative agencies, military, etc. So, police power. At the federal level, we have the FBI, of course, but we also have all of these various agencies, the IRS, the EPA, the FAA, the FCC, the FTC, the SEC, all of Atomic Energy, Department of Education. Those are all administrative agencies. And what I want you, for purposes of this class, those administrative agencies have the ability to make rules. They're called administrative rules. And we'll get into those more later. But what I want you to know is those agencies, for purposes of our three branches of government, fall under the executive. Now, there are some that actually fall in the legislative, but we're not going to get that detail. So for purposes of this class, when I talk about executive power, the power to enforce the law, that's within the president, but also within the various different agencies, the administrative agencies, the bureaus, the commissions, the bureaucratic state, if you will, falls under the executive branch. And that's been the trend. We're seeing civil enforcement through the EPA, et cetera, as part of that. And we'll get into that more throughout the term. So for today, basic function number one, make law, Congress, legislative power. Basic function of government number two, enforce the law, executive power, office of the president. Next, we have under Article 3, down here, the judicial power of the United States shall be vested in one Supreme Court, that is the United States Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish. All right? So, what is the basic purpose or function of the judicial branch? What is the judicial power, in one word? To do what with the law? Various different words apply. The one that I use, and most of the time that you will hear, is interpret. interpret or apply the law, okay? Interpretation. Now, when I say interpretation, what do I mean by that? Or to apply the law. The role of a court is to decide a case brought to the court by the executive branch and to determine whether a law has been broken or what law would apply to the circumstance. And then, as part of that function, a judge or a group of judges like the U.S. Supreme Court may have to decide whether a law is valid, whether it's constitutional, whether it's been preempted, and interpret what that law means. And I'll give you more examples throughout the term. So a judge has to apply, that is decide, does this law apply to this particular situation? That's interpreting. Does the law apply? What does the law mean? What does a word mean within the law? So that's what the role of a judge. And then, part two of the judicial role is to impose either a punishment or what's called a remedy for a violation of the law. That's the application or apply law. So, in brief, in a nutshell, we have three branches of government: the legislative branch, the executive branch, and the judicial branch. L-E-J, or J-E-L, however you want us to do it. That's a test question. It's a simple one. You should all get it right. What are the three basic branches of government? Legislative, executive, judicial. What are their three basic functions? Make law, enforce the law, interpret the law. Now, this is leading up to the second fundamental concept of the United States legal system. And this is the idea that we have these three major functions of a political power, a government, divided into three separate departments or branches. That was done on purpose when the Constitution was written. Why? Well, first of all, let's back up. What's that called? There's a term for dividing these three powers. You know what it is? It starts with S. What was it? Close. That's the same idea. The term is this: separation of powers. Separation of powers. This is the second fundamental concept that starts with the letter S. And you can see this might be a fill-in-the-blank question. The first is supremacy, which we've already talked about. Next is separation of powers. This is the fundamental idea that power of government should not be held by one person or by one group, that it should be spread out. And in the case of the U.S. government, into three branches. This is on page 10 in the current version. Page 11, I think, in the old version, which is posted. So this is the idea: separation of powers, that the legislative branch has a primary function to make law, executive to enforce the law, judicial to interpret and apply the law. Now, behind this idea of separation of powers is also the idea that one branch of government does not have the power to go beyond the scope of its basic authority. So in other words, a judge, their job is to interpret the law, not to make law, and not to enforce the law. In other words, it's not the role of a judge to go out and investigate whether a crime has occurred, to execute a search warrant, to search somebody's house, to interview witnesses, to initiate criminal charges. That's the job of the executive branch. Part of the enforcement function is also the investigative function. That is to investigate whether a crime has occurred or a civil law violation, to gather evidence, to formally issue charges through the prosecutor, either the DA or the Attorney General, and then bring those charges to the judge, for the judge to decide, along with the jury, depending. So, if one branch of government is acting outside its authority, so if a judge is engaged in enforcement, or if the legislative branch is engaged in investigative and executive function, or if the executive branch is engaged in writing a law, that's outside the scope of its authority. And that's called a violation of separation of powers. And that does happen. Primarily, we see that mostly with administrative law that goes beyond the scope of their authority. And I've had to argue that in the real world, both in court and in administrative hearings. That's a violation of separation of powers. All right, so back to separation of powers. The idea of dividing these powers up was done intentionally. Why? What was it, the purpose of organizing our government in that way? To avoid what type of government? Historically speaking, colonies came from what type of government? English. Monarchy, dictator, same thing, right? Monarchy, yeah, so King James, monarchy. So the idea of having separation of powers in a monarchy, or even an oligarchy where you have more than one person in charge, but let's just say it's a monarchy. One person has the legislative power, so the king or the queen or whatever the monarch is, has the power to make law, and the power to enforce the law, and the power to apply judgment. And so all three fundamental powers held in one person or one group of people, depending on whatever it is, like the triumvirate back in ancient Rome. So the idea of dividing or separating these powers is the idea that as a republic, we don't want all of these powers vested in one person or one group of people to provide checks and balances, which we'll get into later. Okay? Checks and balances. That way, there has to be a sharing of power, various branches working together to pass law, to carry it out, that kind of thing. All right, so that's a fundamental concept. Now again, the concept of separation of powers, we see that concept throughout all levels of government. Federal, state, city, county. So at the federal level, we have the U.S. Congress, the President of the United States, and the U.S. Supreme Court. Same concept at the state level. So in Oregon, we have the Oregon Legislature, which we have the Oregon State Senate, and the Oregon House of Representatives. We have an executive, which would be like the president. What's the name of the executive in state law?
Wouldn't that be the governor?
The governor. Yeah, the governor, exactly. So the equivalent of the president for a state is a governor. And then we have the judicial branch within a state. So in Oregon, we have Oregon state courts, including an Oregon Supreme Court, to decide Oregon state law. Same thing at a county level. We'll have the county commissioners. We have potentially county courts. Same thing at a city level. We'll have city council, the legislative. You have a mayor, which is the executive, and you have a municipal court, which is the judicial branch of the city. So the same idea throughout multiple different levels of government. Fundamental concept. We also have supremacy at the state level. Highest level state law will override a lower level state law, just like we see in the federal system. So these two there's three of them. We'll get to the next one next week, following next class. Okay. So separation of powers. All right. So back to page 3, sources of law. So again, U.S. Constitution, two basic functions of the Constitution. Number one is to organize how government is established. At the federal level, We have the U.S. Constitution, which sets up the legislative, executive, and judicial branch. That's the organizational function. Now, the second function, of course, is to reserve rights. So where does that happen? Well, let me show you. Back to page 5. So the first 3 articles are really the organizational articles. The rest of the Constitution, really interwoven throughout the Constitution, are Reservation of Rights. And then, of course, we get into the amendments. With the first 10 amendments, this is where we find a majority of those rights that have been reserved. What do we call the first 10 amendments? The Bill of Rights, right? So, First Amendment, for example, freedom of speech, freedom to peacefully organize, the freedom to petition the government for redress, freedom of religion, freedom of the press, Fifth Amendment, right to remain silent, Sixth Amendment, right to an attorney, right to confront witnesses, Eighth Amendment, right to be free of inhumane punishment. So within the Bill of Rights, that's where we have a lot of these rights that have been reserved. But it's not just there, it's throughout the Constitution itself. 14th Amendment, equal protection, all throughout the U.S. Constitution, okay? Now, I use the term reserve rights. What does reserve mean? Preserve, reserve, kind of the same thing. As opposed to give rights. The Constitution doesn't give you a right, it reserves your right. What's the difference there? It's huge, fundamental difference. Why do I say reserve instead of give? You may know. Is the yeah, go ahead.
Because they can't be taken away?
Okay, well they can, but you're on the right track. So you have rights that are fundamental. In other words, as soon as you are born, these rights attach. I mean, it's all theoretical, right? But the idea is you're born with these rights. You already have them. They're not given to you by the Constitution. You already have them as a human. And so the idea of a right is they're reserved, or another way of saying it's protected, maybe, by the U.S. Constitution and other laws. So, yeah, they can be taken away. That's part of your right to due process, is to stop that. So like one fundamental right you have is the right to be free to move, right? Now, can that be taken away? Obviously, we're seeing it. But yeah, if I'm put in jail for, a felony, my right to freedom of movement has been constrained. So they can be taken away, but in order for that to happen, I have a right to due process. That is a right to a trial, a right to an attorney, a jury, etc. So, and we'll get into that kind of off and on. You were absolutely on the right track. So the idea of reserving rights is you already have these rights. They're yours. To take them away or to limit them, however, must be done in a constitutional way. That's called due process. So way more detail than I'll get into, all right? I just want you to have these fundamental ideas. So number one, supremacy. That is, federal law or higher level law will override a lower level law. First concept, fundamental, throughout our whole system. Concept number two is the concept of separation of powers. That is the idea that each branch of government has their fundamental power, and they're supposed to stay within that realm. And if they don't, if they deviate, it violates separation of powers. It's unconstitutional. And then finally, we have the third one, which is we haven't talked about yet, which is when courts decide cases, and we'll get into that in a couple class sessions. All right, so for today, we're kind of at a break point, so I'm going to break there for today. Let me turn off my